And
Oh, oops.
I'm sorry, I forgot to record it before. Start the recording.
and the people would be getting, he would need to be represented in this probate proceeding by a guardian ad litem, and the court would probably appoint a guardian ad litem for Anthony and for Veronica also. And we note that Anthony lives with his mother, Patricia Haley, in New Jersey. So, and Veronica lives with her stepmother and Edward's surviving spouse in New York. So in the description of the legacies, they're going to say how, we're going to say what portion of the estate you're going to get. And in this portion, in this section of the petition, math skills are definitely required, because you need to figure out, as Amy had pointed out during our preparation for this, you need to figure out what portion of the estate they're going to be inheriting pursuant to the will. So in this case, Anthony Riley, because his mother, no, not his mother, because the decedent's surviving spouse, Anne Riley, is getting half of the estate, then and in the will, Anthony is going to be getting 1/6 of the residuary estate, because Anthony, Veronica, and Dominic, 3 people, are dividing half of the estate. So they get 1/6 each. And so each of Anthony and Veronica are getting 1/6 of the residuary estate. And they are also, they are each the remainder beneficiary of 1/2 of the testamentary supplemental needs trust for the benefit of Dominic Astor, which is in the will, a supplemental needs trust, because one was not established for him during the lifetime of Edward Riley, who was his court-appointed guardian, and there's no successor. So the supplemental needs trust is on page 2, Article 5, and it goes until page 4. And so Anthony and Veronica are mentioned that they are the remainder beneficiaries of half of the supplemental needs trust for the benefit of Dominic, should he die. And then 1/6 of the, so that's Veronica and Anthony, okay? And Dominic is the son who's living in a community residence, and we listed there that the person interested in his welfare is his mother, Frida Astor, who might very well go ahead and apply to become the guardian for her son. But in the meantime, I think the court would appoint a guardian ad litem for Dominic. And what does Dominic get under the will? He is the beneficiary of the testamentary supplemental needs trust. And it's worked out in the will so that hopefully he will be able to enjoy what he is legally entitled to enjoy from his father's estate, and also be the recipient of Medicaid in the community residence. So this section is a very important one, and there are notice requirements and living in state or out of state, and minor or not minor. So basically under 14, a beneficiary is entitled to, a child is child's parent or person with whom they reside is entitled to notice of this probate petition. So that would be the case for Anthony and for Veronica. And for Dominic, it would be, I think, a guardian ad litem would have to be appointed by the court, but it wouldn't hurt to let his mother know about the proceeding, and that's why we listed it. We listed Frida Astor's name in 6B under Dominic Astor.
Before we go on to paragraph 7, I just want to announce the first code. First code is House, House. The first code is House, House. Thank you.
Okay, so paragraph 7 is now we're allowing a catch-all situation here, because we're going to want to make sure in paragraph 7 essentially that we're listing the names of all of the individuals who are interested in the estate under the will, either in a fiduciary capacity or as a beneficiary of the estate, and who have not previously been listed in paragraph 6A or B. So under 7A, we list the names and domiciliary addresses of all substitute or successor executors, and of all trustees, guardians, legatees, devisees, and other beneficiaries named in the will, and or trustees and beneficiaries under any inter vivos trust designated in the propounded will, other than those who have already been named in paragraph 6 herewith. And again, paragraph 7 is bifurcated as paragraph 6 is, so that in A, you're listing those persons who are competent and not under a disability. And in paragraph B, you would list each of those indicated individuals who are under a disability, either because of age and being a minor, or because they suffer from some developmental or other disability that would cause them to be defined as disabled. So in our case, the first individual that needs to be listed is Frida Astor, and that is because she is the trustee of the Testamentary Supplemental Needs Trust for the benefit of Dominic Astor, her son, which trust is beneficiary of 1/6 of the residuary estate. And then the second person listed is actually the decedent's attorney, Harold S. Jorgensen III, and he has been designated as the successor executor and the successor trustee of the Testamentary Supplemental Needs Trust for the benefit of Dominic. In paragraph B, any of the indicated individuals who are minors or under a disability would be listed. In our case, there are none. Now, it's important to note in 7A that typically it is not the case here, but in many instances it is the case that there are other beneficiaries listed in the will who are not otherwise distributees and therefore are not listed in either paragraph 6A or 6B. So if there are other beneficiaries named in the will who do not fit within the paragraph 6A or B categories, they would then be listed under paragraph 7A or 7B. The main difference between the two, as Lynn indicated, is that the parties listed in paragraph 6A and B are jurisdictionally required parties to the probate proceeding and will be issued citations in order to establish a jurisdiction over them, whereas in paragraph 7A, the parties are entitled to notice of the probate petition, but are not required to be served with a citation. And so they're not technically what one would call jurisdictionally required parties, but they're parties to whom notice must be provided. And there is a separate form, a notice of probate form, that is completed with the information that's included in paragraph 7A or 7B. And then that notice is sent to the persons listed so that they will have notice of the proceeding. So in this case, a notice of probate would be sent to both Frida and Harold, and attached to the notice of probate would be an affidavit of mailing, which would indicate that the notice has been sent to them. If there are beneficiaries under the will and they're minors, they're basically, the notice is served upon them in the same way as one would serve them with a citation. And by that I mean, if they're of the age of 14 or over, they're entitled to receive but still a minor. So if they're under the age of 18 but over the age of 14, they are still entitled to receive. They are then in that situation entitled to receive a copy of the notice directly, but a copy of the notice is also sent to their parents. If they're under the age of 14, then only a parent receives a notice. So it's analogous to a situation regarding the service of a citation on a minor. So that's
Harry, can I
paragraph.
break in with a question?
Yes,
Robert Lewis, when you serve the notice of probate, do you have to send the will as well?
you do not. Now, that's a question of practice. I oftentimes will send a courtesy copy of the will just to forestall a beneficiary asking me for a copy of it or asking more information about it. It is not required, though, and there are times that strategically it is better just to simply send a notice of probate and not send the will. But it's not legally required, which again is a distinction with a citation, and a citation, a probate petition, specifically requires that the will be served with the citation and that the affidavit of service recite the service of the will along with the citation. So on to paragraph 8 now.
Actually, I'm going to pause us for 1 second because we have a question. The question is about whether it would be advantageous to have set up the SNT separately rather than as part of the will to avoid probate. So maybe I'll ask Lynn, since Lynn's the one who wrote the will.
Of course, in hindsight, yes, it would have been better to have a supplemental needs trust executed beforehand. So if it's not funded, it would be subject to probate anyway, because unless it is funded, but if it's not funded with what the will says it's getting, it would have to be probated anyway. So the best thing is, if you have a person who is under a disability, do planning with supplemental needs trust, and for that I recommend an expert in supplemental needs trusts and in the laws regarding Medicaid in the state where the person resides, or where they might reside in the future. You have to know the nuances of that anyway. So I think that's my answer to that.
All right, thanks. All right. Back to our regularly scheduled program, paragraph 8.
This paragraph 8 sounds like a fairly straightforward none or description whether a beneficiary named in the will had a confidential relationship with the decedent. And then that paragraph gives an example, such as an attorney, accountant, doctor, or clergy person, which we can perhaps think of as a de jure confidential relationship. For those of you who've practiced in the circuits court or in other instances where a confidential relationship can be pursued or alleged or claimed in some kind of litigation, say in order to either recover funds or to allege a breach of fiduciary obligation, then you're probably aware that there could be a de facto confidential relationship between, say, a decedent in this case and another person, because they were handling their affairs for them. They were basically, the decedent had turned over their financial decision making to that person, even though they weren't officially in a confidential or a de jure confidential relationship, because they were not one of those categories of persons, a doctor, clergy person, accountant, or attorney. Well, for purposes of the probate petition, you don't have to get into those kind of esoteric analyses. And basically, if the person is not one of those categories, I think you're safe just to say none at that point in time. And then somebody can always later on, if they're going to say in a will contest, they may say, well, they were in a confidential relationship. I think the facts bear it out, and even get a jury instruction in a will contest of a confidential relationship. or in motion practice too. But for purposes of the probate petition, the court just wants to know if they were in one of those classic confidential relationships, and if so, and if there's a yes, then the court's going to require some kind of explanation, particularly if it's an attorney wrote him or herself themselves into the will. It's going to require, you know, a Putnam affidavit and other kinds of scrutiny in that regard. Interesting take on the facts in this case is, if we go back earlier, and if Ms. Astor was not able to be the trustee of the supplemental needs trust, and Mr. Harold Jorgensen then had to step forward and was going to be the proposed trustee, not the successor trustee, and he's the attorney for the decedent. The trust is in effect the beneficiary, not the disabled child. A disabled child is a once removed beneficiary, is beneficiary of the trust. So if the trust is the beneficiary, the trustee of the trust receives it, you know, would that trigger a yes under this paragraph? You know, it might. Of course, then the attorney was not, in this fact case, was not the one who drafted the will, but it might trigger something. So sometimes, particularly if it's not going to cause a problem with the scrutiny, the additional scrutiny, it might be better as attorneys just to disclose and say, you know, I think so, and explain what the relationship is in that circumstance I just gave. Other than that, though, the court's pretty much looking for your classic de jure status of a confidential relationship. And if you put none, and then it turns out later on that there's a factual dispute whether the person was in a confidential relationship or not, you're not in trouble if you put none here in the probate petition.
And I'm just going to chime in that Bill mentioned the Putnam affidavit. So those are going to be required by the court whenever there is someone in the classic confidential relationship. And that's a reference to a case called Matter of Putnam from 1931. And in that case, there was it was held that there was an inference of undue influence whenever there's a beneficiary under the will who was in a confidential relationship with the testator. And so the Putnam affidavit is generally, it's where the recipient, the beneficiary, who is oftentimes a clergyman, but sometimes a doctor or an accountant, says, yes, I knew this person and we were friends, but I in no way influenced them to put me in their will, and I didn't know about the bequest prior to death. And so if you file that Putnam affidavit at the same time as your probate petition, it could save you a little back and forth with the clerk's office.
Okay, for paragraph 9, we're gonna look at the fact pattern that was given to everyone on September 12th, and hopefully will be included in the materials also for this, so we can see how we got $9,124,500 in personal property, and improved real property, 0. So in 9, you're going to fill that out based on the statute of and the filing fee statute, because the filing fee is going to be directly related to paragraph 9. So for estates over 500,000, the filing fee is the top filing fee amount, which is $1,250. And the court wants to see that, and they want to collect the right filing fee. And in this case, because Edward won the Powerball lottery, his estate was greatly magnified. And if we had done the will in hindsight, the will would have had a trust for the minor children as well, because they're young. But you know, he died at 54 years old, and he hadn't won the Powerball lottery yet. Anyway, so the personal property consists of the co-op apartment located in Nyack, New York, that was bought for $65,000 in 2016, but 2016, but it was worth $325 at Edward's date of death. So the probate attorney needs to work with the executor to get a date of death value for the cooperative apartment. And it's personal property because it shares a stock as opposed to a house or a condominium, which is real property. And they're asking for personal property and improve real property in New York State. So if you have property outside of New York State, you're going to need to do an ancillary probate in the other state where that real property is located. And in order to circumvent that, we try to do trusts, but that's another lecture. But you could avoid ancillary probate by doing a trust and putting that out of New York State property in there. And you could avoid probate completely if all your assets are in that trust too. But so the cooperative apartment now, if anything, any asset has a named beneficiary, such as the joint account at City Line Bank with his wife, Ann Riley, that's not listed in this probate petition because, as we know, that asset, that bank account will pass by operation of law to his surviving spouse, Ann. And it does not need to be mentioned here. And then there was also a life insurance policy, which has a whole other nuance to these facts, with naming his ex-wife, Patricia Haley, as beneficiary, and his mother, Rosalind, Edward's mother, Rosalind Riley. So Rosalind predeceased Edward, and Patricia and Edward got divorced. So the divorce terminates the beneficiary status unless it's actually mentioned in the will with the specifics of it, which it's not here. So you may remember that we had in the administration petition that the ex-wife has a claim against the estate because of her separation agreement with Edward and divorce judgment. And so that's where we got 9,124,500, a lot of dough. Okay. 10. Larry?
Excuse me, I was on mute there a second, so I wouldn't interfere with your soliloquy.
You were taking a new call from a client who has
Exactly,
$20 million.
Exactly. So
That's
under
what you were
paragraph,
doing. Be honest.
paragraph 10 is another one of these due diligence paragraphs, and it's very simple and straightforward. It says, upon information and belief, no other petition for the probate of any will of the decedent or for letters of administration of the decedent's estate has heretofore been filed in any court. Now, again, this is in any court, not just in the Surrogate's Court of Rockland County or in a Surrogate's Court of the State of New York, but any court. And generally speaking, again, that would be true. There are circumstances, however, where there might have been a petition for probate of the same will filed in a different state or even in a different country, which is conceivable. And it's also possible that letters of administration were sought even though the will existed, because another party may have believed that the will was invalid and sought letters of administration, and yet you believe the will is valid and you're seeking to probate it. So to the extent that any of those special or different type factual circumstances exist, paragraph 10 can be amended to properly set forth the facts and circumstances as they relate to your particular petition. And that would be helpful to inform the court as to what the purpose of your petition is and why your petition has been validly filed. It's then up to the court to determine if one proceeding should be held in abeyance or stayed pending the resolution of the other or not, but that's something then for the courts to sort out. In the normal situation, in 99% of the cases, the answer is that there has been no other proceeding, and so no modification to Section 10 is required. And so then we would move on to the wherefore provision.
And
I'm just going to chime in for a sec that with so many of these forms that are promulgated, there's stuff included in them that may not be applicable to your particular situation. And it's tempting to skip over those due diligence paragraphs, but you're really much better off if they're not true, crossing them out. So like in this case, paragraph 10, sometimes there are competing wills. And if you're the second filer with a different will, then you could just draw a line through paragraph 10, because obviously it would not be true if you're filing a second petition with a different will. But I think that there's a temptation sometimes to just ignore the stuff that you don't have to fill anything out for, like in that paragraph. And so I'm just saying, don't do that. Please read them and make sure that those paragraphs actually apply to your case.
And to supplement what Amy just said, the official form, you may have facts that you'd like to bring to the court's attention. If you feel that the form, you feel constricted by the form.
I can tell you right now, I'm in a Zoom class right now. Call me at 2:30.
And you don't want to get too involved with, or you're worried about crossing out too much of the petition or rewriting it because it is an official form. You can always supplement your petition with an affidavit or your affirmation, depending on what you feel is appropriate. And so, for example, with 10, if it was that there's a will being probated, say in another jurisdiction or another country, and it's not a competing probate. In other words, it's a separate will that says it's good for that country, and your will is going to be probating for assets located in the United States for all U.S. proceedings. You could say, see accompanying affidavit. Also, you can do that. You can supplement the petition with an affidavit and or an affirmation as need be. So going on to the wherefore clause, perhaps just as a preface, many of you I saw as you all were appearing in here, a lot of you could be teaching me on probate practice, very experienced probate practitioners. But for those of you who are new to Surrogate's Court is a special proceedings driven court. Everything starts as a special proceeding. And the process that's going to issue is going to be either a citation or an order to show cause, or for a particular type of proceeding, if you're bringing a discovery turnover proceeding, it will be an order to attend and be examined. So that's what's going to be issued by the court rather than the service of a summons. And that's basically what the wherefore clause is saying in this instance here. And hearkening back to Larry's very cogent explanation of paragraphs 6A and 6B, interested parties who require a citation. If the party is not under a disability, in other words, if they're an adult or they do not have a developmental or other cognitive disability, rather than serving them with a citation, they can be provided with a copy in a probate proceeding, a copy of the will, and what's called a waiver of citation and consent. And in many instances, probate proceedings proceed without any kind of a citation. It's a waivers and consents are circulated with a copy of the will to all the interested parties in 6A. And if they sign them and return them, you can file that with all your other probate documents with the court, and then the court can consider jurisdiction complete over those individuals and go on with the probate proceeding without a citation. It just so happens in this case, three of the four distributees, the three children, are under a disability of one type or another. So that's where our explanation was talking about the citation and the need for the appointment of a guardian ad litem. So anyway, in the wherefore clause, you're basically asking the court to issue, service. It's going to be either a citation or, as with even a Supreme Court proceeding, if you feel there's some need for some kind of preliminary or interim relief, such as a TRO while the probate proceeding is pending, and you have sufficient evidence to justify a TRO while the case is proceeding, that maybe there's a dispute about whether an asset truly is passing outside the will as a testamentary substitute, say a joint bank account. It's not your position. This is not a true joint account. It's a convenience account. It belongs to the estate, and the joint donor is threatening, or you feel that they've already started to pull assets out of the joint account and you want to preserve the status quo, and you have the evidence to support it. You can submit your affidavit and or affirmation and or memorandum of law as needed with the probate petition and ask for an order to show cause with a TRO while the probate proceeding is pending. It's not typical, of course, but it's theoretically possible, and you would set that forth in the information following the wherefore clause. So in this case, the wherefore clause is saying you're asking for letters testamentary issued to Anne Riley. That's the document issued by the court that officially appoints the executor. I'm sure we've all received at one point or another a call from the client saying, I went to the bank, can you write that letter for me? The bank wants the letters testamentary. And then you explain saying, I don't write it. It's a document issued by the court. And in this case, also, we want letters of trusteeship because there's a testamentary trust, a trust to be created under the will, and a trustee has to be officially appointed. So that's where that box is also checked off. Letters of trustee you want to be issued to Frida Astor for the trust for the benefit of Dominic Astor. And that's the end of that portion of the petition.
So this is a good time. I'll interrupt again with code number 2. Code number 2 is box, B-O-X. The second code is box, B-O-X. So please be sure to write down box on your attorney affirmation sheet. Thank you.
And I'm going to interrupt too. Well, I guess not interruption. I'm just going to put a question out to the panel, which we got. What do you do if your client has no idea what the value is of the estate when you're filling out, I think it was paragraph 8. You want to, yeah, Bill, go ahead.
Okay, so the law and the court rules acknowledge and anticipate that at the time you're petitioning for probate, the petitioner may not know what the full value of the assets are. That's why that paragraph says to the best of the undersigned's knowledge. And that may be the case because for those of you who practice and trust in estates law, if your client contacts third parties, particularly financial institutions or transfer agents for stock, and the asset is owned by the decedent, it's going to be a probate asset. It's not a testamentary substitute. Well, 9 times out of 10 or more than that, 99 times out of 100, they're not going to respond or provide information. They're going to say, well, we need proof that somebody's been appointed by the court as the legal representative of the estate, letters testamentary or letters of administration, whatever the case may be, before we'll give that information. So that's why with regard to providing an estimate of the value of the assets, it says upon information and belief. And it's wise to discuss that with your client and have them give their best estimate. As you may or may not know, the court charges a filing fee when there's a probate proceeding, and the filing fee is based on the estimated value of the probate assets. It's broken into brackets. And based on the current filing fee regimen, if you're estimating assets of $500,000 or more, then there's going to be the maximum filing fee of $1,250, and that's it. Whether it's $501,000 or $55,000,001 or $55,000,000,001, it's still going to be a $1,250 filing fee. So, for the most part, what the court's interested in, or the UCS is interested in for that estimate, is what kind of a filing fee to charge.
Yes.
However, with you representing the petitioner, particularly if you anticipate there might be litigation later on, either in a probate proceeding or in an accounting down the road, and you know that this is a sworn document that your client's filing with the court, you may just want to discuss it with your client and just make a note of the diligent effort that's been made to estimate the value of the assets, so that if they're questioned about their petition later on, saying, you said the value of these assets were less than 500,000, and this turned out to be, worth more than $9 million, trying to cast aspersions on the veracity and the credibility of that particular person for that later subsequent legal proceeding. As long as you've spoken to your client saying, well, that's the best information we had at that time. And then later on, though it's a little beyond the scope of our proceeding today, you will be filing an inventory of assets, which is not due until 9 months after the executor has been appointed, not 9 months after death, 9 months after the executor has been appointed, the inventory of assets is due. So again, it's the court rule system and the statutory regimen anticipating and acknowledging that you may not have that information until you've been appointed and the estate's been up and running, and you have legal authority now to make inquiry and get a better idea of the value of the assets.
And if it turns out that you underestimated and you were under the $500,000 number, but then in fact it's more than $500,000, the court will make you pay the rest of the fee.
And the court won't issue any current letters of trust of letters testamentary until they get that filing fee.
That is true. We're not as quick to offer a rebate though. If you you do get it eventually, but not quite as quickly as we will demand the increased fee. All right, so back to our petition, we have the next section is the combined verification, oath, and designation. But I've lost track of whose turn it is. Is it
Okay,
Evelyn?
it might be my turn, and combined verification oath. This is where the executor says that they will faithfully and honestly discharge the duties of fiduciary, and that they are not ineligible to receive letters, and what their domicile is, and designating, of course, the clerk of the Surrogates Court of Rockland County as the person upon whom service of process issuing from such court may be made, as if it were served personally upon me. And in the case of the trustee who's the successor trustee of the Supplemental Needs Trust, who is an attorney, attorneys who are named as fiduciaries in wills need to have their home address, not their office address. The court wants to know where they actually live. And in this case, Anne lives in Nyack, and she is the executor, and she signed the combined verification oath and designation. And then there is a if we scroll down on that page, Amy.
Mm-hmm. Oh, sorry.
It's okay. So there we have an acknowledgement that will be filled out for Anne Riley and signed by a notary public, and the attorney who's preparing the probate petition would sign this page, and then their name, firm name, and address, email, and telephone number appears there. And that's the end of page 7.
Right.
And then page 8 would be if it was for a corporation. So it would be a corporate designation there, and oath by the corporation to serve when the petitioner to be appointed is a bank or a trust company.
Could I add
Oh, go
something?
ahead. Go ahead, Bill.
In this case, of course, we have another person who we want to be appointed as a fiduciary who's not the petitioner. and that is Ms. Astor, to be appointed as a trustee of the trust for her disabled son. So there is, in preparing for this, I couldn't find an official UCS form, but there's a form, there are forms out there. And if you need help, Larry and Lynn and I have forms for that too. Where when you have somebody who's going to, assuming they're going to cooperate and they want to be appointed trustee in this case, you cannot be appointed by the court until you have filled out your oath and designation. Those are the second two parts of that page 6 that we just looked at, the combined verification, oath, and designation. So they're not a petitioner, so they're not signing the verification, but they're signing oath and designation. So there is a separate oath and designation for somebody who's not being a petitioner, and you would get them to sign it. Now, it doesn't hold up your whole probate proceeding. You could file with this, and if in this case Frida Astor was delayed in okay, so we have her oath and designation form there. So Amy, I stand corrected if there's an official form for that. When I went in the website,
that's the one that you prepared.
I know I prepared it from another template, but I mean, I didn't see an official UCS form in the Surrogate's website of forms. So, but I know it's available in a lot of the form books or whatever. Just be aware of it. That's all. If you're ever asking in a petition for somebody to be appointed as a trustee or as a co-executor, say, and they're not the petitioner, they're going to need to file an oath and designation also before the court appoints them. Just be mindful of that and to get that signed and filed too.
Oh, all right. We have another question to backtrack a bit to 9B regarding potential causes of action. So I could start that, which is the most common additional cause of action that you'd find in a probate or an administration petition is a wrongful death or personal injury claim. Sometimes the personal injury claim has already been started. Usually in the probate and administration petition, it's just a potential wrongful death and personal injury claim, often against a nursing home, but not always. And so that's the most likely thing that you would put in there. But let me hear from the rest of the panel.
Well, we noticed that our letters testamentary in Rockland County have been that even if we don't say there is a cause of action, possible cause of action, the fiduciary is limited to not collecting any proceeds of a cause of action. But that's fine. The court is keeping track of what's going on and wants to be apprised of and wants people to know about the cause of action that may be present. So if one is already existing, then you have to list it there. If you don't know whether you're going to bring one, there's a question of why put it in there if you're not sure that you're going to be suing, for instance, the nursing home for lack of care of the person in the nursing home. So, and if it's none, you say none. They don't like, the court doesn't like any paragraph left blank. They want that none there.
Yes.
Or they want the information. So they don't want to be guessing what you meant.
Right, because if it doesn't say none, maybe you just forgot to fill it out. But if it says none, we know that you read it and you said the answer is no.
Mm-hmm. Mm-hmm.
The thing to remember also is that it's conceivable there could be a cause of action. When we think about this, we often think of, obviously, or most frequently, we think of a cause of action for wrongful death or conscious pain and suffering. But you could well have another action. You could be a petitioner in a civil lawsuit, or a plaintiff in a civil lawsuit. You could have, it could be a breach of contract action. It could be any number of different things. And in an action such as that, you would have to be substituted out. The executor would have to be substituted out as the plaintiff once the executor is duly appointed, and information regarding that type of lawsuit would have to be included and should be included in the petition as well. So one shouldn't think about it as being solely related to personal injury, wrongful death, or conscious pain and suffering.
Right. All right, there's another form. We prepare some of the ancillary forms that I'm going to share right now. I think I understand how this works. So great. Do you guys all see the affidavit of comparison? Did that
Yeah.
show up?
Yep.
Yes.
Okay, great. Which you will need to include when you're submitting a copy of the will.
And I think this is interesting too, because once we went to the NICEF system, we have to complete the affidavit of comparison and complete it fully. And I generally strike out information that's not relevant to my particular situation. So if it's, and if it's, basically I'll normally, you only need one person if you're actually attaching a photocopy of the will, which in current times is really the situation all of the time. You're not going to be doing a transcript, so you don't need two. So you're basically going to do one and then more or less conform it. And if there's no codicil, you can strike out that portion about there being a codicil. But interestingly, when you file your probate petition and supporting documents through NICEF, you're going to need to do the affidavit of comparison with the will attached, but you're going to have to separately file a copy of the will without the comparison attached to it through NICEF. And then, of course, the rule is that you then have to provide the original will to the court immediately after the filing with a copy of your filing receipt issued by NICEF. So at that point in time, as well as if you pay the fee, which you can do, you can pay it using credit card initially at the time of filing, but you can also do it the old-fashioned way, which is to have a check. And if it's an initial probate filing and you don't have an estate account, you're going to need a certified check or a bank check. But you can include that along with the certified copy of the death certificate. So those are the things that through the NICEF system are going to have to be filed immediately with the court upon the acceptance of your probate petition documents, the original will and any related codicils, a copy of the certified death certificate, a copy of which you're also going to file through NICEF, and the filing fee if you have not already paid it. And then you will receive an acknowledgement back from the court as to that fee. And the other thing you're going to do when you file through NICEF is you're going to indicate how many certified letters you're going to request, which of course is very important in connection. We're talking about those letters, the letters that the bank wants, any financial institution wants and whatnot, to evidence your authority to act. And upon the filing, you're going to be asked how many copies of the raised seal, certificates of appointment, letters testamentary you're going to want. Typically, it's 5 or 10 copies, depending upon the number of assets that you reasonably expect you're going to need them for, because it's easier to request more at the get-go than come back and ask for additional copies, and they're $6 each. So your filing fee is going to be the filing fee as calculated according to the schedule, plus $6 per letter, a testamentary certified letter that you ask for, and they're going to come with the raised seal stamp of the court affixed to them.
And one comes with a gold seal on it. And I always have a question: do I, if I have two executors, do I give preference to one of them by giving the gold one to them, or do I just keep it in the file? And I just keep it in the file.
That's what I do too. I keep it in the file.
All right, we're actually almost out of time. So are there more questions? We also can show you some more forms. So that weren't necessary in this case, but other forms that you might need to fill out. But does anyone else have any questions?
There was another point that I wanted to make, which relates to a comment that Bill had made and one that you had made, Amy, as well. And that's to be very strategic and plan in advance as to exactly all the documents you're going to need, and try to get all of them executed and submitted from the get-go. So as Bill was mentioning, is if there's been a delay in probate for more than a year, you know you're going to need an affidavit of delay. That's not a specific court form, but it's a form you create which basically explains why you reasonably delayed the probate of the estate. Another one might be is if there was a confidential relationship and you're going to create a Putnam affidavit. Another situation could be is if, God forbid, someone unstapled the will. You know, one of the things that we always talk about in trust and estates practice, when a new paralegal is hired by a firm or assistant or secretary or an associate, we always explain that once a will is stapled, it may never be unstapled. When you copy it, never unstaple it. Never unstaple a will. That's sort of drilled into you. But nonetheless, there are circumstances where someone inadvertently unstaples a will to make a copy or otherwise. That's a problem. It's not an obstacle that can't be overcome, but requires, again, an affidavit explaining the circumstances of why it was unstapled. Oh, gee whiz, the paralegal unstapled it to make a copy, and that's why. Or if I did it inadvertently, I unstapled it, or whatever the facts may be, as long as it's a reasonable explanation. So try to get all of those affidavits in and collated together and file them at the same time. This way, you're not involved in a back and forth with the clerk, or you're minimizing the back and forth by anticipating all the documents that are going to be required.
I'm curious, Larry and Bill and others who practice in this field, has anyone ever been presented with an unstapled will by their client at the get-go? Unstapled.
In the 3-ring binder.
Yeah, or in the 3-ring binder.
Yeah. By a
submit
Florida
it to the
attorney who
court?
prepared it. Yeah.
Let's say it wasn't in a binder. It doesn't matter. It's the same principle.
Paper clipped. Yeah.
Would you staple it, or would you just give it to the court exactly as you received it?
Well, nowadays with e-filing, it's easier if it's leaving it unstapled anyway, and then just submit it. I would submit it with an affidavit that it was found.
I would do the same. Right. I agree with Bill. I would do the same thing, because again, it raises a presumption of the fact that there could have been an insertion or removal of pages. And so an affidavit, of a person with personal knowledge to say this was the will of the decedent, and it is the full and complete will, and all of the pages are properly and accurately represented, or whatever phraseology you're going to end up using.
I would definitely do that too.
All right, I'll just show the one additional form we have that Lynn was talking about. I believe it was Lynn earlier. This will has a self-proving affidavit, but sometimes they don't, or sometimes they're not properly created. And so then you need an affidavit of the attesting witnesses. So let me just pull that up.
Right, and while Amy's pulling that up, I will do the last code. The last code is STAR, S-T-A-R. The third and last code is STAR, S-T-A-R. All right, thanks.
Okay.
Did we go over the one very important form, the waiver of process, consent to probate? We have that form, and that obviates the need for a citation in a lot of instances. And so that's a great tool to have, a waiver of process, consent to probate by an interested party. So
we didn't have that one in this case. I guess that's why we didn't fill it out, because nobody is able to waive in this case.
Right, and the petitioner doesn't have to waive because she's the petitioner.
Right.
Right.
But that's absolutely right. In a very typical situation where you might have, say, 3 adult competent children, and oftentimes people will say, well, is a probate of a will of that sort difficult? And the answer is generally not, if everyone is agreeable and say one child is the petitioner and the other 2 sign waivers. I would say that more often than not, the vast majority of the probate proceedings I file are filed with waivers and consents, and there's no need for citations to be issued or for there to be any sort of court appearances. That's a neat and clean probate.
That's nice.
And,
I have no experience with that. Because if they come to my desk, there's usually something going on.
In those instances where you're going to need attesting witness affidavits, just be mindful that, and it says right in the affidavit, when the attesting witness is asked to sign it after the decedent has passed away, they're supposed to have been shown either the original will or a court certified copy. So if you have attesting witnesses who've since moved away and you're going to be mailing them their affidavit, obviously you don't want to mail them the original will. And what you in that instance can do is you can submit the will, the original will, to the court with a death certificate, and then you can order a court certified copy at that time, even if you haven't filed a probate petition yet. And then you can mail the attesting witness affidavit along with the court certified copy to the attesting witness to have them sign their affidavit and then return to you, and then you can file it with the court.
okay. And at the end of the petition, we usually put in that waiver of a bond requirement, because I believe in this will, I'm checking it right now, we put in that there would be no bond required. And yep, on paragraph, Article 13th of the will on page 5, fees, commissions, and no bond. No fiduciary except for, this is interesting, we do have someone, Frida Astor shall be required in this case to furnish a bond. So we could just ask for the waiver of the bond for Ann Riley.
Right. Okay, so we have a few minutes left. One more question is, can a waiver and consent be executed in place of sending out a notice of probate?
Yes, it can be. It can be. And you may want to just highlight that in your cover letter to the court, because in one or two instances, it kind of threw off the clerk in the court until they reviewed it with the powers that be. But absolutely, that can be done.
Great. All right. So it's 1:53 according to the clock on my computer, which means if we don't have any more questions, we can wrap up this fabulous program and get ready for the next one. So is there anybody else who has any questions they want to ask? All right, so thank you everybody so much for attending today. And we will, when we set the date of our next class, which will be at the end of November, we'll inform everyone. And feel free to tell us which forms, oh, wait, maybe one more question. You would like us to cover? Oh no, there's a comment. So if there's any forms that people would particularly like to have us review, you can put that on when you do the feedback on the class, so that will help us to plan. But that's it. Thank you so much, everyone, for joining us today. And I hope you have a great rest of the day.
Thank you, Amy. Thank you, Barb.
Thank you, Amy. Thank you, everyone.
Thank you, all attendees.
All right.